Having established the definition and common structures of Arizona's planned communities and condominium associations, it is essential to understand the disclosure responsibilities that accompany real estate transactions involving these communities. Disclosure obligations within HOAs are not merely administrative. They are legal duties designed to ensure fairness, transparency, and full awareness for both buyers and sellers. Arizona law requires specific documents and information to be shared in every transaction involving a property governed by an HOA or COA. These disclosures protect the integrity of the transaction and uphold consumer confidence in Arizona's real estate system. Under ARS, Paragraph 33, Chapter 16, Planned Communities, and ARS, Paragraph 33, Chapter 9, Condominiums, the seller is legally responsible for providing the buyer with a complete disclosure package that includes essential information about the association's financial health, governing documents, and any restrictions that affect ownership or use of the property. This requirement ensures that the buyer is fully informed of the obligations, fees, and potential limitations associated with HOA membership prior to closing. Seller responsibilities. In Arizona, the seller plays the primary role in initiating disclosure. Within 10 days after the purchase contract is accepted, the seller must provide the buyer with the following documents and information: a copy of the association's covenants, conditions, and restrictions, CC&Rs, the bylaws, and any rules and regulations adopted by the association, the most recent financial statements, including the annual budget and reserve fund information, the most recent annual meeting minutes, and details of any pending litigation involving the HOA, a statement of unpaid assessments, special assessments, and transfer fees, a description of any known violations of the community's governing documents by the seller or the property itself, the name and contact information of the HOA's management company or designated representative. If the association charges a fee to prepare this disclosure package, it must be reasonable and clearly stated in the purchase contract. The law limits how much an HOA can charge for document preparation, typically capped at $400 under most association policies. Buyer responsibilities. The buyer, once in receipt of these documents, must review them carefully to understand their ongoing obligations. This includes knowing the amount and frequency of assessments, understanding architectural restrictions, and reviewing the HOA's enforcement procedures. If the buyer finds any information unacceptable, Arizona's purchase contracts generally allow for a 5-day cancellation period after receiving the full disclosure package. This right to cancel
ensures buyers are not locked into agreements without full knowledge of their commitments. HOA responsibilities.
While the seller provides the documents, the HOA or its managing agent often plays a supporting role in the process. The association must respond to document requests in a timely manner and ensure the information is accurate and current. Under ARS, Paragraph 33, 1806A, the HOA must deliver the requested disclosure information within 10 days after written notice, or the buyer may cancel the contract without penalty. The HOA is also responsible for disclosing any pending lawsuits, liens, or anticipated assessments that may affect the property or the buyer's future ownership. Licensee responsibilities. Real estate licensees are expected to act with care and diligence under Commissioner's Rule R4-28 R1101B by ensuring that all required disclosures are made and that buyers are aware of their rights and obligations. A licensee who fails to advise a buyer of HOA fees, rules, or restrictions may be subject to disciplinary action for negligence or misrepresentation. Agents should confirm that the disclosure package has been delivered, reviewed, and acknowledged before the close of escrow. For example, if a buyer purchases a home in the Power Ranch HOA in Gilbert and later discovers a $5,000 special assessment for street repair that was not disclosed, Both the seller and the listing agent may face legal consequences for non-disclosure. Similarly, if the agent fails to verify whether the HOA allows short-term rentals, the buyer could find themselves in violation of community rules shortly after closing. Practical example. Consider a buyer purchasing a condominium in the Optima Camelview Village COA in Scottsdale. The seller's disclosure package must include information about the association's reserves, upcoming roof replacement projects, and the monthly assessment fees. If the buyer learns that there is an impending $15,000 special assessment to fund structural repairs and decides the cost is too high, they can cancel the purchase within the 5-day period after receiving the disclosures. Case example: Johnson v. Point Communities, Inc., 2003. In this Arizona case, the Court of Appeals ruled that buyers must receive timely and complete HOA information before closing. Failure to disclose material facts, such as pending assessments or litigation, constitutes a breach of contract and potential fraud. The decision reinforced the importance of full disclosure to maintain fairness and transparency in HOA-governed transactions. Discussion. What is the primary purpose of HOA disclosure requirements in Arizona? Answer. To ensure buyers are fully informed about the community's financial condition, rules, and obligations before completing the purchase. What rights does a buyer have if they receive HOA disclosure documents and find terms they cannot accept? Answer. The buyer has the right to cancel the contract within 5 days after receiving the complete disclosure package. What role does the real estate licensee play in the HOA disclosure process? Answer. The licensee must ensure all required disclosures are delivered and explained to the buyer, maintaining compliance with address standards of care and honesty. Review summary. In Arizona, real estate transactions involving properties within HOAs or COAs require a high level of disclosure and accountability. Sellers must provide buyers with the association's CC&Rs, bylaws, financial reports, assessment details, and other relevant documents within 10 days of contract acceptance. Buyers must review this information to understand their obligations, while HOAs must provide accurate and timely data. Licensees serve as facilitators and compliance monitors, ensuring that the process meets statutory and ethical standards. These requirements, found in ARS, Curve 33, Chapters 9 and 16, protect consumers by promoting transparency and preventing post-closing disputes. Understanding and adhering to these disclosure responsibilities not only ensures compliance, but also reinforces the professionalism expected in Arizona's real estate industry.